Good morning. This is the matter, a continuation of the trial in the matter of Elsie, case number 25-50783NA. Present in the virtual courtroom, we have the mother's attorney, Mr. Toburin. We have mother's guardian ad litem, Kristen Newhouse. We have father's attorney, Roman Kasorik. The child's attorney, Carolyn Gaston, various agency workers, and a foster parent. As I indicated, we did commence this matter on July 16, 2025, took substantial evidence and testimony, and then during testimony, it was discovered that the mother alleged Native American heritage, and that proper notice had not been given to the tribe. So the court stopped the hearing and rescheduled it for continuation today. Mr. Vanderkolk.
Thank you, Your Honor. I have since learned that notice has been given to the named tribes. Two decided to respond via registered, when they were given notice via registered mail, and two tribes ignored the notice and the requests, those being the Blackfoot tribe and the Oklahoma band of the Cherokee tribes. So we have done or provided adequate notice to the known tribes, and so I believe that we can proceed. And I'd recall Ms. Siver just to take some brief testimony on that notice.
All right. Ms. Siver, if you would unmute. And you are still under oath. Do you understand that?
I do.
Okay. Mr. Vanderkolk.
Thank you. Ms. Siver, could you tell the court what steps were taken to notify the three Cherokee tribes and the Blackfoot tribe of potential Native American heritage claimed by Ms. Harmon?
Yes, back in May, I sent registered mail and certified mail to the 5 tribes, the Cherokee tribes, the Blackfoot tribe, and the BIA. I received response from 2 of those tribes, and then the remaining 2 that I did not hear from, we sent the 5598 and the 120 again via email to them, and have called numerous times and also emailed, followed up with another email.
All right. Well, when you say, you know, the other tribes, no one knows what you're referring to. So can you specify which tribes responded and which tribes ignored the requests?
Yep. So the 2 that did not answer to our request were the United Kiwaton Band of Cherokee Indians in Oklahoma, and then the Blackfeet tribe of the Blackfeet Indian Reserves in Montana. The 2 that did reply were the Cherokee Nation and then the Eastern Band of Cherokee Indians.
All right. And what did those 2 Cherokee bands reply with? That she does
not have Native American, or that Elsie does not have Native American heritage.
All right. So we have no indication that Elsie has any Native American heritage whatsoever after you sent registered mail notices or requests to the known tribes, correct?
Correct.
All right. Thank you. I have no other questions.
All right. On that issue, Ms. Gaston, any follow-up questions just on that issue?
No, Your Honor.
All right. Thank you. Mr. Toburin?
No, thank you, Your Honor.
All right. Mr. Kasorik?
Yes, Your Honor, real quickly. Ms. Siver, what was the date of the mailings of registered mailings of the original requests?
I don't recall off the top of my head. May I please refer to my notes?
Please.
It was May 19th of 2025.
Thank you.
All right. Any follow-up, Mr. Vanderkolk?
Not with this witness, Your Honor.
All right. Ms. Gaston?
No, Your Honor.
Mr. Toburin?
No, thank you.
All right.
I'd ask that this witness be excused, Your Honor.
All right. Any objection to excusing this witness?
No, thank you.
No, Your Honor.
All right. Thank you. You're excused, Ms. Siver.
Thank you.
I'd call Renaya Bush this time.
Ms. Bush is no longer employed with Samaritas. I'm her supervisor and prepared to testify for today.
Very
And
well.
I would just indicate that we did take testimony from Ms. Bush at the last hearing.
I would call Jennifer Plavin.
Okay. Ms. Plavin, would you raise your right hand? Would you state your name and spell it for the record?
Jennifer Plavin, Jennifer Plavin.
And do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Ms. Plavin, you were Renee Bush's supervisor on the Elsie case. Is that correct?
Yes, that's correct.
All right. And you're familiar with this case?
Yes, I am.
You heard her testimony at the initial adjudication hearing. Is that correct?
Yes, I did.
All right. So I believe that we were ready to start with the best interest factors, if I'm not mistaken. Are you prepared to testify to those?
Yes, I am.
All right. Could you please discuss Ms. Harmon's parenting ability as it pertains to Elsie's best interests?
Yes, during the duration of the foster care case, Ms. Harmon has attended 9 out of 22 scheduled visits with Elsie. When she has attended visits, some of them, Ms. Harmon has been engaged and affectionate. Other times, she has been a little withdrawn and has spent, more time on her phone than interacting with Elsie. Yeah.
Do you believe that what she's demonstrated in her parenting ability weighs in favor of termination or against termination of her parental rights to Elsie?
In favor of termination.
All right. Are you aware of any psychological evaluation under the same topic? Are you aware of any psychological evaluations that Ms. Harmon has undergone?
She was referred to one through HRA that was scheduled for August 7th. However, she did not attend this assessment.
So moving on to Elsie's need for permanent stability and finality, could you please discuss Ms. Harmon's ability or lack of ability to provide permanent stability and finality for Elsie and Elsie's need for that?
Yes, Ms. Harmon, over the past several months with the foster care case, has been inpatient twice for mental health. She's also been residing at Degage. She has not been able to provide stable residence in order to care for Elsie.
And Elsie does need permanent stability and finality?
Absolutely, yes.
Okay. Also, I'm sorry, I forgot about the unknown father. Do you have any information on the unknown father to Elsie?
Yes, Ms. Harmon did provide a name, Mr. Carter. He was contacted while he was incarcerated upon his release on June 16th. Since that date, we have not been able to reach him. We previously had several phone numbers for him, but none of them are in service. We also reached out to his mother, but she has not responded to us as well.
So we have no information on this putative father's ability to provide permanent stability or finality?
No, we do not.
And same question for the unknown father?
Yes, just due to his lack of involvement and whereabouts, we don't know whether he would be able to provide a stable residence for Elsie.
Sways in favor of termination of both parents' parental rights?
Yes, it does.
Is there a bond between Ms. Harmon and Elsie?
Due to her lack of consistency, it's hard to say. She's only attended 9 visits since Elsie was removed from her care back in May. So I don't think there is a strong bond, which would weigh in favor of termination.
Okay. You don't think there's a strong bond? Is there any bond? Is there a weak bond, in your opinion?
Honestly, I can't say that there would be. She hasn't visited. I think the last visit she attended was 7/28. So it's been just about a month now. And with Elsie being so young, without seeing her mother consistently, there's not going to be a strong bond between them.
All right. And if, same for the unknown father, there's no bond there, correct?
No, there is not.
So if both parents' parental rights were terminated, would Elsie still be able to grow and develop in a healthy manner if whatever bond that may exist were to be broken by termination
Yes, I do believe Elsie would be able to grow.
in a healthy manner?
Yes, I do. Yes, correct.
You wouldn't be too traumatized by a termination?
No, I don't believe so. I think due to her young age and the lack of consistency with the parents, I don't think there is a strong bond that would be broken.
All right. Does this weigh in favor of termination of both parents' parental rights?
Yes, it does.
Could you please discuss the advantages of the current foster home over both Ms. Harmon and the unknown father's homes?
Yes, the current foster home where Elsie is placed has been able to provide a safe, stable, nurturing environment. They're able to meet all of her needs. They've been able to follow up with some medical attention. We have no concerns with her placement. It's been a very stable placement for Elsie.
Whereas Ms. Harmon's home is unknown?
Correct.
Okay, same for the unknown father?
Yes.
But Mr. Vanderkolk, you're, for whatever reason, I don't know if you're turning your head, but we're losing some of your, what you're
I
saying.
will bring my laptop closer and try to keep my head facing the microphone.
Thank you. It's much better.
I'm sorry if I just asked you this, but does this weigh in favor of termination of both parents' parental rights?
Yes, it does.
All right, could you please discuss Ms. Harmon's visitation history as it pertains to Elsie's best interests?
Sure. Since Elsie was removed in May of 25, Ms. Harmon has attended 9 out of 26 parenting time visits that have been scheduled for her. During the visits that she does attend, sometimes she was very attentive and nurturing. Other times she appeared more withdrawn and would spend more time on her phone than paying attention to Elsie.
All right. Does this behavior weigh in favor of termination?
Yes, it does.
There's no visitation history with the unknown father, correct?
That's correct.
Are you aware of Ms. Harmon engaging in any questionable relationships during the pendency of this case?
No, I'm not.
All right. Same for the unknown father.
Not that I'm aware of now.
Was a parent agency treatment plan prepared for Ms. Harmon?
Yes, it was.
Could you talk about her compliance with that as it pertains to Elsie's best interest, please?
Yes, Ms. Harmon has not been in compliance with her parent agency treatment plan. She was referred for a psychological evaluation on August 7th that she missed. She was referred for foster care supportive visitation. This program began 7/21 of 25. She attended 2 sessions and then due to her lack of communication is being closed. We'd already discussed her poor attendance during parenting time visits. Miss Harmon was inpatient twice, once at Pine Rest and then Forest View. She was referred or she was engaged in the PhET program through Arbor Circle. However, they did feel she needed more intensive care and was referred for Network 180. Due to her lack of contact with the agency, it's unknown whether she started with Network 180 for her mental health and substance use treatment.
All right. And had an unknown father come forward, you would have offered a parent agency treatment plan for him?
Yes, we would.
So does this factor weigh in favor of termination of both parents' parental rights?
Yes, it does.
Could you please discuss Elsie's well-being while in care?
While she's been in care, Elsie has done very well. She's a very happy baby. She appears to be developmentally on track. She was behind on immunizations, and there were some concerns with her hearing. However, she was able to have an audiology appointment and caught up on her immunizations. She was also seen for some acid reflux and prescribed medication. But overall, she's doing very well in care.
Does this weigh in favor of termination of both parents' parental rights?
Yes, it does.
Is Elsie in a pre-adoptive home?
Yes, she is.
And does this weigh in favor of termination of both parents' parental rights?
Yes, it does.
Um, let's see. Is the current foster care home a relative or fictive kin placement?
No, it is not.
Is Elsie old enough to express a preference regarding the possible termination of Ms. Harmon and the unknown father's parental rights?
No, she's not.
Could you please discuss the length of time that Elsie may be required to wait for Ms. Harmon to overcome the barriers that brought this case to court?
Yes, due to Miss Harmon's significant history of mental health, substance use, and parenting concerns, I do think it would take a substantial time for her to be able to demonstrate stability for the court before Elsie would be safe in her care. I think, we'd probably be looking at least 12 months of stability for her.
Let's see. Since the last hearing, has Ms. Harmon inquired as to Elsie's well-being?
Um, She has attended a couple of visits, but otherwise has not, when she's been missing visits all of this month, she has not asked about Elsie's health or well-being, no.
She hasn't provided any care, custody, or support for Elsie?
No, she has not.
Do you have a recommendation for the court today?
Yes, recommending that Elsie remain in her current licensed foster home or with an approved relative, that termination of parental rights for Miss Harmon and Mr. Carter, and the case is reviewed in 90 days.
You say Mr. Carter, but Mr. Carter's not the legal father, so are you
That's correct.
recommending?
Yes, I apologize. Any unknown father.
Oh, all right. Thank you. I have no other questions.
All right, thank you. We kind of jumped ahead from adjudication to disposition, and so I'm going to back up here and just so that the record is clear,
Oh,
and ask, let's see, Ms. Gaston, did you have any witnesses that you wanted to call regarding adjudication? And you're muted. Okay. No, you're sorry.
Additional witnesses, no, I do not, Your Honor. I believe that we had all the witnesses as to the
Okay. I just
necessary.
want to make sure that we cover and give everybody the opportunity. Mr. Kasorik,
No, Your Honor, thank you.
Mr. Toburin.
No, Your Honor, thank you.
All right. Then I will ask for statements regarding the adjudication. Mr. Vanderkook.
thank you, Your Honor. I believe that the testimony well, it hasn't been controverted by any evidence. I believe that the requisite burden of proof has been met by preponderance of the evidence, and actually I'd argue that it's been proven by clear and convincing evidence. So I'd ask that the court find that Elsie falls within the jurisdiction of the court and make Ms. Harmon and the unknown father respondents at this time. Thank you.
All right. Thank you. Ms. Gaston.
Thank you, Your Honor. I concur with the statements of Mr. Vanderkook. My notes reflect that Ms. Stiver testified as to paragraphs A, B, C, D, E, F, G, H. Ms. Barnsdale testified as to paragraph J, and my notes reflect that we did hear from the hospital staff as to paragraph I. So I believe each and every one of the paragraphs has been proven. There is a prior history of terms with both parents, and I think that certainly the petition has been proven and adjudication should take place.
Thank you. Mr. Toburin.
Your Honor, I will place a general objection on the record to my client, Ms. Harmon, being made a respondent. Thank you.
All right. Mr. Kasorik.
Your Honor, I would also place a general objection as to the unknown father.
All right. Thank you. I don't know that we need to hear from Ms. Newhouse, but I will ask.
Thank you. I would also join with the general objection on behalf of the mother. Thank you.
All right. Thank you. The court has reviewed its notes from the commencement of this trial, as well as the testimony and evidence today, and does find that, first of all, there is probable cause to believe that Cabrian Carter is the putative father. But that at this point, that the putative father of Liliana Carter is unknown and cannot be identified due to the testimony that we heard about attempts to contact that person and a lack of response. That respondents, Ms. Harmon and the unknown father, did not appear, but were represented by attorneys. Ms. Harmon, the court will note that Ms. Harmon did show up for part of the original, the initial adjudication on July 16th, but left before it was completed. That by preponderance of the evidence after trial, that there are statutory grounds to exercise jurisdiction over this child, specifically failure to provide, when able to do so, support education, medical, surgical, or other necessary care for health or morals, abandonment by parents, guardian, or other custodial or other custodian, an unfit home or environment by reason of neglect, cruelty, drunkenness, criminality, depravity on the part of a parent, guardian, non-parent, adult, or other custodian. Contrary to the welfare findings were made in a prior order. The custody of the child with a parent presents a substantial risk to the child's life, physical health, or mental well-being. The court orders that this child be placed with the Department for Care and Supervision. And at this point, we will continue with the dispositional evidence, and the court will take judicial notice of that evidence that was provided during the adjudication. All right, Ms. Gaston.
Thank you, Your Honor. With respect to disposition, Ms. Plavin, did you prepare a case service plan that was submitted just recently, an addendum?
Yes, we did.
And is that addendum, let's see, dated 8/19/25?
Yes.
Did you also prepare an initial case service plan with parent agency treatment plan dated 6/13/2025?
Yes.
I'd move for the admission of those two as Exhibit 1, Your Honor. And should I just run through a series?
Unless we already know there's an objection to something, yes, go ahead and list them.
Okay. As to forensic fluids, did you have those taken for Ms. Harmon and submit them to the court and all parties? Originally, the collection date was 6/9/25, but subsequently you've submitted 3 more from 7/10/24 to 7/28/25.
Yes.
All right, I'd ask that those be added together as Exhibit 2. Was there an initial Arbor Circle progress report dated 7/8/25?
Yes.
And then did you submit recently the Arbor Circle termination of services letter dated 7/24/25?
Yes.
I'd ask that those be added together and marked as Exhibit 3. With regard to Ms. Harmon, did you submit recently a Network 180 adverse benefit determination dated 7/24/25?
Yes. Correct.
I'd ask that that be marked as Exhibit 4 and admitted. Whoops. Yeah, that's right. Was there also a recent Forest View discharge packet submitted to all parties?
Yes, there was.
And that concerned the second visit to the hospital for Ms. Harmon and ending sometime in early July. Is that correct?
Correct.
I'd ask that that be marked and admitted as Exhibit 5. Initially, did you provide us with a series of, or have you reviewed a series of CPS investigation reports with complaint dates of 1/2/2008, 9/3/2010, 9/2/2020, And then 4/23/25 having to do with Ms. Harmon.
Yes.
I'd ask that those be marked and admitted as Exhibit 6. Have you reviewed prior termination orders out of Wayne County concerning a denia 09-017828-N being a part of the case number, and then as to Christian 08-475-662, which I believe may have been previously admitted, but those are the prior termination orders. Is that correct?
Yes, that is.
Just in case they weren't admitted, Your Honor, I'd like to have those marked and admitted as Exhibit 7. The current CPS investigation report was dated 5/17/25. Is that correct?
Correct.
I'd ask that that be marked and admitted as Exhibit 8. And finally, I believe the medical records for Liliana from Corwell Health. Did you have an opportunity to review those?
Yes.
And I'd ask that that packet of records be marked and admitted as Exhibit 9.
Any
So we-
objection?
No, Your Honor.
objection, Your
No
Honor.
objection.
All right, they're all admitted.
All right. Your Honor, with regard to some of the testimony, can you take judicial notice of the questions asked by Mr. Vanderkook during sort of the latter half of adjudication, or did you want me to inquire?
No, I think I can take judicial notice unless there's something you need to, I mean, you can follow up on anything you'd like to follow up on, but I don't think we need to repeat all of that unless I'll open it up for objection to either, does anybody have an objection to my taking judicial notice to that testimony?
I do not.
No objection.
All right, thank you.
Thank you. Okay, Ms. Plavin, have Liliana's immunizations been updated?
Yes, they have.
And what services was she referred to early on?
Yes, she was.
And was that with respect to holding her bottle and some motor skill issues?
Correct.
And what were the findings, and is there an ongoing program?
I have not received the report at this date, but we'll follow up to see if they're going to be working with her.
All right, thank you. Does she have eczema, and has she been provided with appropriate medical care for that issue?
Yes, she has.
With regard to Ms. Harmon, she continues to have unstable housing, is that correct?
That's correct.
And with regard to emotional stability, based on the exhibits submitted and your review of them, have you been able to determine whether or not she is seeking appropriate care for her mental health?
At this time, it's unknown. She was working with Arbor Circle, but they closed out her case due to her needing more intensive care with Network 180. She was scheduled for appointments with Network 180, but due to the lack of contact with the agency, it's unknown whether she attended these appointments.
And we have a letter of adverse benefit determination from Network 180, isn't that correct?
That's correct, yes.
And what does that reflect?
Just her high level of care that's needed for her treatment.
With respect to her history, she has a history of domestic violence and inappropriate relationships, is that correct?
That's correct.
And has she engaged in any service to address those issues?
No, she is not.
Are you aware of any major supports that she has within the community?
We are not, no. She originally is from the Detroit area. With her moving over here, I'm not aware of any support or family that she has.
Are you aware of where she's currently residing?
Last we knew, she was at Degage after being discharged from a mother's touch.
And when is the last time you've been able to make contact with her?
The agency was able to talk with her yesterday about a parenting time visit that she missed. But that was, I think, the last time.
And when the agency contacted her yesterday, did they remind her of today's hearing?
Yes, she was reminded.
Do you have any understanding of why she's not here today?
I do not know.
Okay. The psych evaluation, she failed to attend that, is that correct?
That's correct, yes.
That was a service that you provided, true?
Yes.
All right. Did you refer her to Enhanced Women's Services at Arbor Circle?
She had started that program on her own.
Is it your understanding of 19 visits, she had no-showed for 1 and canceled 4?
Yes.
And then Arbor Circle ultimately indicated that they had to terminate services. Is that correct?
Yes, that's correct.
And they also indicated that if she wished to continue with them, they would be available to her at any time, true?
Yes, they are, yes.
And are you aware as to whether or not she's made any contact in an attempt to reestablish services?
No, I'm not aware of any contact.
Okay. At one point, was she involved with Network 180 in a targeted case management program?
Yes, she was referred to them.
And that didn't happen. Is that your understanding?
To my knowledge, yes.
Her diagnosis is bipolar with paranoia and psychotic disorders. Is that correct?
Yes, it is.
With respect to Mr. Carter, do you have any understanding of where he is at this time?
We don't. After he was released from jail in June of 25, he has not had contact with the agency. He did provide a few numbers and his mother as a contact, but we have not heard back from him or his mother.
And was the agency at one time able to discuss with him the possibility that he was the biological father of this child?
Yes, when he was incarcerated, we were able to have a visit with him to discuss that.
And did you indicate what steps he might need to take or that he should take if he wished to establish his paternity?
Yes, he was notified that he would need to engage in a DNA test for that.
And it's correct that he has not come forward to do any of those things. Is that right?
That is correct, yes.
Liliana's foster parents, are they willing to be long-term placement for her? In fact, even adoptive parents?
Yes, they are.
Okay. Your testimony earlier was that it was in Liliana's best interest if we move forward with termination today. Is that correct?
That's correct, yes.
And you say that because she has a need for permanence due to her age, correct?
Yes,
Lack of bond with either parent,
correct.
possibility of adoption,
Yes,
length of time it would take for mother and or father to rectify the conditions that brought the child into care. Is that accurate?
that is, yes.
Well, then you earlier for Mr. Vanderkook testified that you were recommending, that the child remain a temporary court ward and that we have a review hearing in 90 days. But are you actually in favor of termination today?
Yes, we are.
And you think that would be in the child's best interest?
Yes, to provide her the permanence she needs.
Okay. I have no further questions, Your Honor. Thank you.
Thank you, Mr. Toburin.
Ms. Plavin, when you talked to Ms. Harmon yesterday, did you have a chance to talk to her about whether she wants to continue to work a treatment plan?
No, the caseworker had offered to drive Miss Harmon to a visit in order to talk with her. We've had, I think, a difficult time getting a hold of her as of late to talk about services and her intentions.
Do you know whether the conversation yesterday was over the phone or?
It was over the phone, yes.
Okay. Do you know whether Ms. Harmon understood the purpose of today's hearing?
Yes, I do believe she was aware of the hearing and the intentions of it.
You think she knew that termination of her parental rights was a possibility?
Yes, I do.
Do you know whether she responded directly to her feelings regarding that issue?
No, she has not.
Okay. And prior to yesterday, when was the agency's last contact with Ms. Harmon?
I talked to her. I apologize, I don't have my phone in front of me. A couple of weeks ago, she did not confirm for her visit, so I called to follow up on that, and I was able to talk to her, and she canceled a visit.
Okay, during that conversation, excuse me, did she indicate her intent to continue with the treatment plan?
She did not know. She did talk with the caseworker July 24th, and she had stated that she wanted to get Lily back, but if not, she was open to adoption. It was open.
Okay. Did you discuss with her what your expectations would be in the very near future if she re-engaged in her treatment plan?
Yes, she was aware of services that she was referred to.
And did you discuss with her a possible timeline? You mentioned earlier that it might take a year for her to re-engage and complete her services. Did you discuss that timeline with her?
No, we did not specifically discuss timeline. I think a lot of it just would depend on her engagement with services and progress that's made.
Your Honor, thank you. I have no further questions.
Thank you, Mr. Kosorik.
Thank you. Mr. Carter is a putative or an unknown father at this point, right?
Yes, he is.
Have you spoken to Ms. Harmon about whether or not he is, as far as she knew, if he was the biological or legal father?
That is who she named as the biological father, yes.
Okay. And what efforts has the agency made to reach out to Mr. Carter during this report period?
Yep, we were able to talk with him when he was incarcerated. Upon his release, we have tried several phone numbers we had for him. I believe there's 3 numbers. We've also tried to contact his mother. We've done social media searches, looking on jail and Otis. At this time, we've been unsuccessful in reaching him. He did indicate when he was released from jail that he would be homeless, living in the Warren area. So we do not have a good address for him.
All right, that would be the Detroit area, actually, he was jailed in the Macomb County Jail at the time this petition was filed, right?
That's correct, yes.
Did he at any point indicate that he's interested in becoming the legal father and taking care and custody of Elsie?
Yes, he did say that he'd be willing to do a DNA test.
Okay. But he's not followed through on that with the agency.
No, he is not.
All right, thank you. Nothing further.
Mr. Vanderkolk.
I have no follow-up questions, Your Honor.
Ms. Gaston.
No follow-up, Your Honor. Thank you.
All right. Mr. Toburin.
No, thank you, Your Honor.
All right. Ms. Gaston, any additional witnesses?
No, Your Honor.
Mr. Toburin, any witnesses or
thank you.
evidence? Mr. Kosorik, same question.
No evidence, no witnesses.
Thank you. All right, statements. Mr. Vanderkolk.
Thank you, Your Honor. As all the best interest factors weigh in favor of termination of both parents' parental rights, and the statutory grounds have clearly been met by the requisite standard of clear and convincing evidence. I won't rehash all the facts, but Ms. Harmon is clearly incapable of caring for Elsie at this time. The unknown father remains unknown, has done nothing to care for Elsie and has effectively abandoned her. I'd ask that the court grant Elsie the permanent stability and finality she needs now, given the fact that Ms. Harmon has had 4 previous involuntary terminations. I don't see any hope for her within a reasonable amount of time to be able to provide care for Elsie. So I'd ask that the court terminate both parents' parental rights at this time. Thank you.
Thank you. Ms. Gaston.
Thank you, Your Honor. First, I'll inform the court that I did have an opportunity to visit with Liliana in her foster home back in July, on July 9th of 2025. She was doing very well. The foster parents are very bonded to her. Obviously, she's a young child, but so I didn't have an opportunity to glean what she would prefer. But I do believe that she's safe and comfortable in the foster home, and they are willing to be adoptive parents. I will second the statement of Mr. Vanderkolk that I do believe that it is in her best interest to move forward to termination. And I will add that I believe that the agency provided more than reasonable efforts in an attempt to reunify this family. They have offered psychological evaluations. They have assisted in foster care supportive visitation. They had assisted in Arbor Circle's mental health services with the client, with Ms. Harmon. They tried to reach out to the father and did speak to him to become legal father, and he made no efforts to do so. So I do believe that it has been proven by clear and convincing evidence that a termination should occur. Thank you, Your Honor.
Thank you. Mr. Tobirin.
Your Honor, on behalf of Ms. Harmon, I object to her parental rights being terminated today. Thank you.
All right, thank you. Ms. Newhouse.
Yes, I would join along with that and place a general objection. Thank you.
Great, thank you. Mr. Kosarik.
Likewise, on behalf of the putative, or here, the unknown father, I would object to the termination, and especially on his behalf, I would simply argue that it doesn't appear that my client had any prior terminations, so that would not be authorized by statute. And at this point, his initial response to the investigator was that he would like to be the father of this child. That is Mr. Cabrian Carter, date of birth 4/12/93. Thank you.
All right, thank you. The court does find by clear and convincing evidence that the state or that the DHHS has met its burden of termination. I will be giving a separate oral opinion about 11:30. No one needs to rejoin for that if you do not wish to.
Thank you, Your Honor.
Thank you,
All
Your
right.
Honor.
Thank you.
Thank you, Your Honor.
We're back on the record in the matter of Elsie, case number 25-50783NA. Present in the virtual courtroom, we do have the child's attorney, Carolyn Gaston. The court excused everyone else from attending, indicating that the court would be terminating parental rights, but giving an opinion later on. This is that opinion. This matter involves a petition by the Kent County Prosecuting Attorney's Office filed in this court on May 17th, 2025. In the petition, the prosecuting attorney requests an order terminating parental rights and placing the child in the permanent custody of the court. An adjudication was held on July 16th, 2025 and August 26th, 2025, and the child was found to come within the jurisdiction of the court. The mother, Deanna Harmon, was served with notice of this hearing by publication on the Grand Rapids in the Grand Rapids Press on May 30th, 2025. I find that reasonably diligent efforts have been made to locate Ms. Harmon and provide for her presence at this hearing. However, Ms. Harmon did not appear for actually either hearing, although she initially appeared for the July 16th, 2025 commencement of the hearing. She left before the parties went on the record. The attorney for Ms. Harmon did appear for both of the dates of hearing and stated his general objection to the termination of Ms. Harmon's parental rights. The court previously found, pursuant to MCR 3.91D3, that the unknown father and putative father waived all rights to notice, including the right to notice of termination of parental rights and the right to legal counsel, due to his total lack of interest in his child. However, I will indicate for the record that he was represented in today's, actually both hearings in July and today. We are therefore proceeding in the absence of the natural father. Pursuant to statute and court rule, the court has conducted previous hearings, specifically the preliminary hearing and the adjudication on this case, and this court takes judicial notice of the testimony and exhibits received in those prior hearings. Further additional testimony and exhibits have been presented regarding the termination petition. The court has weighed the credibility of the witnesses. The court has also considered the weight to be given to written and oral reports received as evidence and has carefully determined the probative value of those reports. The relevant testimony is summarized in part as follows. This case came into came to the attention of the court and to CPS due to concerns of Ms. Harmon not taking her medication and her ability to care for Elsie when she was in the Mother's Touch program. Ms. Bush testified from Samaritas testified that mother was diagnosed with bipolar disorder with psychotic features and paranoia, that she was at Mother's Touch program through the Maternal Infant Health Program until July 2nd, 2025. Since then, she's been at Dégagé since July 3rd, 2025, and due to not cooperating with the rules at a Mother's Touch program. She was inpatient at Pine Rest for mental health treatment beginning on May 17, 2025, when she was involuntarily committed via Corwell Health Hospital, and then was released back to a Mother's Touch and then readmitted or admitted to Forest View Hospital involuntarily again. When released from Forest View, she went to Dégagé Ministries, which is a homeless shelter here in Grand Rapids. Today, Ms. Siver from CPS testified that on May 19, 2025, the agency sent registered mail notice to the tribes identified by Ms. Harmon, as well as to the Bureau of Indian Affairs. The agency received responses from 2 tribes confirming that there was no Native American heritage to their tribes. 2 other tribes did not respond within the time allowed by the statute. And the court found that there was no Native American heritage for this child. Ms. Flavin from Saberitas testified today that mother has attended only 9 out of 22 scheduled parenting times with this child, the last being on July 28th, 2025, that she occasionally spent more time on her phone than she did interacting with this child. She was referred for a psychological evaluation and missed that appointment on 8/7/2025. She continues to reside at a homeless shelter, specifically Dégagé. There's little to no bond with mother due to this child's young age, which is 8 months, and the lack of parenting time or the inconsistency of parenting time, and no bond with the unknown father. That the foster home is stable. And that mother has not asked about the child's well-being while in care. The child has been referred to early on due to some motor skills issues, that she has eczema, which is being treated appropriately, and that she's doing very well in the foster home, and that those foster parents are interested in adoption. Ms. Harmon has 4 prior terminations of parental rights to other children. She has a significant history of substance abuse, although she was testing negative, at least while she was having communications with the agency earlier on in the case. That the Dégagé residence homeless shelter is not appropriate for return of this child. That there is a history of domestic violence with Ms. Harmon. That Ms. Harmon is unemployed and the worker is unsure whether she's taking her medications for mental health. That she was counseling at Arbor Circle, but the case was closed due to a lack of participation by her. She was referred to Network 180 for more intensive services, but the agency was unable to determine whether she has been participating due to a lack of communication with the agency by Ms. Harmon. She was, as already indicated, mother was referred for a psychological evaluation by the agency and failed to appear. Ms. Harmon receives disability payments of approximately $800 a month. That through this case, that mother has been appropriate when with the worker when in person, but makes bizarre statements over the phone, such as being raped by a famous rapper, etc. That Ms. Plavin spoke with Ms. Harmon yesterday by phone regarding misparenting time. The misparenting time at visit reminded her about today's hearing and the fact that it was a termination hearing where her rights could be terminated. Ms. Plavin also spoke with her by phone a couple of weeks ago regarding another misparenting time that Ms. Bush, the prior worker, spoke with Ms. Harmon on July 24th, and she stated that she wanted Elsie back, but she was also open to adoption. The putative father that was named by Ms. Harmon was contacted by the agency while he was incarcerated in Macomb County early in this case. That worker discussed the possibility that he was the biological father of Elsie, notified him regarding the availability of DNA testing. He said he was willing to take a test, but he hasn't followed through with that. He, since being released from incarceration, that the agency attempted to locate him after his release from incarceration via jail searches, social media searches, and their usual protocol. That during his incarceration, when the worker had the discussion with him, he did indicate that upon release he would be homeless. Ms. Plavin also testified that the unknown father has had no parenting time, that there's no evidence of any questionable relationships for either mother or the unknown father, that Ms. Harmon has not been in compliance with her parent agency treatment plan, in addition to not attending parenting time consistently, and when she's attended, not engaging consistently with the child. She's only attended 2 sessions with the supportive visitation worker. In that case was closed due to mom's lack of participation. That again, the child is very happy, developmentally on track, and is caught up on immunizations. That she's not in a relative or fictive complacent. That she's not old enough to express a preference. That it would take at least 12 months for the mother and unknown father to become to receive services or work services to become rehabilitated sufficiently regarding the barriers so that this child could be returned. So based on the evidence record in this matter, the court finds by clear and convincing evidence that a statutory basis exists for terminating the parental rights of Deanna Harmon and the unknown father, including but not limited to the following. Pursuant to Section 19B 3A1, that the father of Elsie is unidentifiable, that the father deserted Elsie for 28 or more days and has not sought custody of Elsie during that period of time. Pursuant to 19B 3G, that the mother, although in the court's discretion is financially able to do so, fails to provide proper care and custody for the child. There's no reasonable expectation that she will be able to provide proper care and custody within a reasonable time, considering the child's age. Section 19B3(1), that parental rights to one or more siblings of the child have been terminated due to serious and chronic neglect or physical sexual abuse, and that Ms. Harmon has failed to rectify the conditions that led to the prior termination of parental rights in those cases. Section 19B3J, that there's a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if she's returned to the home of the parent. That reasonable efforts have been made to preserve and reunify the family, make it possible for this child to safely return home. Those reasonable efforts were unsuccessful. Turning to best interests. The court finds that by preponderance of the evidence that it is in the child's best interest to terminate parental rights. This is based on the assessment of the following factors. The first, the child's bond to the parent. The evidence shows that this child at 8 months old, given the limited contact with mother and the non-existence contact with the unknown father, that she has no significant bond with either parent. This factor weighs in favor of termination. Regarding each parent's parenting ability, the court has no information or evidence regarding the unknown father's parenting ability. That Ms. Harmon's parenting ability, based on the evidence, has been a struggle, and essentially she's unable to parent based on all of the evidence that was provided. This factor weighs in favor of termination. The next factor is the child's need for permanency, stability, and finality. The evidence showed that this child is 8 months old, and mother is certainly not stable or able to provide stability and permanency that this child needs, especially at this young age. This factor weighs in favor of termination. The advantages of a foster home over the parent's home. The evidence showed that this child is thriving in the foster home, that all of her needs are being met. The next factor is the child's well-being. This factor weighs in favor of termination. The next factor is the possibility of adoption. The evidence shows that the current placement is a pre-adoptive placement. The foster home is wishing to adopt. This factor weighs in favor of termination. This child is not in relative placement or in fictive kin placement. This factor also weighs in favor of termination. The next factor is the opinion of experts, including psychologists, therapists, the caseworker, and the lawyer guardian ad litem. Both the lawyer guardian ad litem and the caseworker opined that it is in this child's best interest to terminate parental rights, and this factor weighs in favor of termination. The child's age, as already indicated, Elsie is only 8 months old. This factor weighs in favor of termination. The next factor is the child's wishes of sufficient age to express a preference. This child is not of a sufficient age at eight months to express a preference, so the court finds this one is not applicable. There was no evidence regarding the child's relationship with extended relatives, so the court finds that factor is not applicable. There was no indication that the child has special needs, so that factor is not applicable. The next factor is the length of time the child has been in foster care. The child has been in foster care for 3 out of 8 months of her life, at the most recent 8 months of her life, which is significant. That's almost half of her life. This factor weighs in favor of termination. The next factor is the length of time the child may be required to wait for parents to rectify conditions. The testimony of the worker was that it would take at least 12 months, even if Ms. Harmon were to step up today, fully engage in all services, due to the significance of her many barriers, that it would take at least 12 months. Same thing for the unknown father. This unknown father has no relationship with this child, and it's unknown what if any barriers this unknown parent might have. This factor weighs in favor of termination. Therefore, from the testimony and record in this matter, and considering the legislative mandate for permanency, and by a preponderance of the evidence, the court finds that the best interest of this child will be served through termination of parental rights. The parental rights to Deanna Harmon are terminated, and additional efforts for reunification of the child with the parent shall not be made. The child is committed to the Department for Permanency Planning, Supervision, Care, and Placement under MCL 400.203. All attorneys are discharged except for the child's attorney, Ms. Gaston, and a post-termination hearing will be held before referee Kessler, and we're adjourned.